establishing the trust and administering it initially and administering it after death, it usually involves a team approach of professionals. The estate planning attorney, of course, is involved at the beginning and is involved with some of the actions after the first death and after the second death and making sure things flow. But because you may have estate tax or even income tax complications, it's always good to involve a CPA or an accountant, and then certainly depending upon the type of assets you have, it may also be necessary to have your investment advisor involved so that the correct decisions can be made. At times, assets need to be sold to pay for taxes or pay other bills, and you need that investment advisor information so that you make prudent decisions in that regard. You need a CPA so that you maximize your tax effects, and then the attorney ties it together. So we often talk about a team approach to administering the trust.
Great, thank you, Mark. I know that really resonates with us and will for many of our clients as we work with them on some of these matters. And I think in general, the material we've covered today has been extremely helpful and beneficial. Hopefully we've debunked a few myths that folks carry around with them. We do have time for questions right now. Again, you can submit your questions using the GoToMeeting control box in the upper right-hand corner. And again, if we don't get to your question or if you think about it after the fact, please don't hesitate to contact us directly. In addition, I'll make the offer that should you have a question that may pertain to Mark, his practice, his background, or his services, you can certainly contact us and we will put you in touch with him if that seems appropriate. We have a first question coming in, which is, if I'm single, are there the same advantages of having a living trust? Mark?
If you're single, well, the example I gave really dealt with a married couple. If you're single, you can benefit from having a living trust in terms of ease of administration. Your successor trustee can take over, do the administration upon death without court involvement. You don't go through probate. That's the main advantage. You don't receive any of that exemption trust benefit because there's only one trustor. But I think the administration is still a benefit, or the ease of administration is still a benefit to the trustor.
Great. Speaking of trustors, there's a very relevant question here that just came in. It reads, is the trustor required to inform the successor trustee of the forthcoming trustee prior to their death assignment?
Key word there is required. No, they're not required, but better practice would be to let them know. Depending upon the size of the estate, you're going to want to possibly involve that successor trustee ahead of time. You're going to want them to be aware of what this is, and they may be taking on quite a responsibility, and certainly you would want to talk to your prospective successor trustee before you select them so that they have an idea of what's going on and are not really hit cold by this. A lot of clients ask me if they should give their will to their children and let them see what's going on, and I always tell them, no, hold that will. Again, it doesn't speak until you pass. The executor in the will be going through a court process, an orderly process. It doesn't have the freedom that the trustee has. But I think it's a good practice to let the trustee, successor trustee, have an idea that they've been named as a potential successor trustee.
There's a few more questions coming in here. The next one is, should I designate my trust as my beneficiary in my IRA and or 401k?
That's another it depends question. Generally, we don't put the IRAs or 401ks into the trust. They have designated beneficiaries, and if it is the desire of the client to just simply turn those assets over to their children, for instance, they can just name the children, and upon presentation of a death certificate, it'll go directly to the children. IRAs can have some income tax implications, and sometimes it's simpler to have it go directly rather than into the trust. On the other hand, sometimes in a trust distribution, there are some special needs. They may have a child that has special needs, so that the trust calls for yet an ongoing special needs trust or something. The testamentary trust will go on for a number of years for the benefit of a child. If it's intended to have those assets benefit that special needs child, then it makes sense to designate the trust as the beneficiary and run those assets through the trust so they get into the ongoing trust for the child.
Great, that's helpful. That's one that we hear from time to time, certainly. The next one is, what happens if the estate planning attorney that wrote my original living trust dies or is no longer available when the first spouse in the trust dies?
The estate planning attorney is obviously the client of the spouses who, is the attorney for the spouses when they do their estate plan, and they would rely on him for questions, or him or her for questions and so forth. But upon the death of one spouse or another, you get into an administrative phase, and the successor trustee is not bound to that estate planning attorney for the administration. If the attorney is not available, or after a while, maybe the client wants to use another attorney, that the successor trustee, whether it's the ongoing, the spouse serving as the successor trustee, or even as the successor trustee after the death of the second spouse, can select any attorney they want to help them with the administration.
Great, thank you very much. I think there's another question here, Mark. You can go ahead and read.
Okay. The question is, what is the difference between holding title as trustee of your own trust and just moving property into your trust and having the trust hold the title? The trust has to be funded, as I mentioned. And when you fund it into the trust, you are holding it as trustee of the trust. So that it's very key, if the property is not, whether it's real property or another asset, is not titled in the name of the trust, it may not be included in that trust administration, may require that pour-over will to put the asset into the trust. So if I understand the question about whether there's a difference between holding title as trustee or just moving, you really can't move it without holding the title as trustee. Once it's in the trust, you are holding title as trustee. It's a trust asset.
Great, thanks. We're getting a few more questions. I think we just have time for one more, hopefully relatively quick one, and that is, what roles or tasks should the designated trustees take prior to the passing of the trustor?
Actually, none. As long as they are only a designated successor trustee, the current trustee is the only one with authority to deal with the trust assets. And the successor trustee who has not stepped in yet, whether it's before death or after death, really has no authority to deal with the trust assets, so there's nothing to do. If it's a good working relationship between parent and child, it doesn't hurt for the current parent trustee to at least keep the child informed of what the assets are, where they are, so that in the event of a death, there's certainly an easier transition. But that successor trustee, until they step in as trustee upon resignation or death of the prior trustee, really has no authority to deal with the assets.
Thanks, Mark. And as we complete here, I would just ask you, is there any final statement you would like to make in terms of the unique estate tax situation we're in right now?
That's a tough question. The estate tax, as I mentioned earlier, there is no tax this year. We believe Congress will act before the end of the year. There's a lot of controversy over whether they'll make their action retroactive to the first of the year. We really don't know where it's going. I do have a personal opinion that they'll probably reinstitute a sizable exemption amount, but certainly don't hold me to that. We don't know what Congress is going to do. It's a big political football, and we just have to wait and see what Congress does.
Great. Thank you very much, and thank you for being here today. And to all of you, have a great remainder of your day, and I'll remind you, we will be sending you a a survey. If you could please fill that out and return it to us, we would greatly appreciate it. And you can tune in next month on Wednesday, August 25th for our investment committee update. Thanks again and have a nice day.